Hello everyone, good evening. Gautam,
Yes, sir.
Gautam, start the program.
Yes, sir, we can start.
Okay, do you start?
Okay. So we have 72 people here, and I think the registered students are around 200 or something, 195. So should we wait more or should we start?
No, listen, this course is not a proper course which is part of their curriculum. So they asked for us, that's why we are giving this course. So we
Yes,
will be
sir.
punctual with the time. We will be punctual with the time. It doesn't matter we have 50 or 70 students, we will be punctual with the time. Because at the end of the day, it is not a thing which we are giving to them. So some students asked me, asked Vijay sir, then we are giving. So it's an extra thing which is given to them, and we are taking extra pressure, extra effort for this particular course. So our effort is that whoever is interested, they will be joining. So I will not be comparing anyone. Is it clear, Gautam?
Yes,
So the
sir.
rules
Sure,
are
sir.
very, very clear.
Okay, sir. So a very
And
good
I
morning.
think, Gautam, the numbers are drastically increasing also. So
Yes,
I
sir. Yes,
think we
sir.
need not worry.
Yeah. Yeah. Okay, sir. A very good evening to everyone present here. So, as you all are aware, that today is the very first session where we are starting with the Consti class. It's an online certificate course, as already been made clear in the inaugural session. You are also aware of the sessions. There are 15 sessions. I will not repeat that. I will just provide you a brief of what we are going to discuss or what we are going to read today. So the today's session is on Constitution of India and introduction. So it will be a very a comprehensive discussion and a very initial discussion on the agenda of how the Constitution came into being, what is constitution, what all are the element of constitution, what is constitutional governance. You all are aware because we have had a lecture on constitutional governance yesterday. What were the historical development which took place before got our constitution into its final being. We will also cover preamble. We will also cover the salient features of our constitution. Now, to deliver the lecture or to discuss, I will not say to deliver a lecture, but to discuss the agenda at hand, we have two of our prominent professors, Ashutosh sir and Udit sir. Welcome, sir. Thank you for giving us
Thank you,
time.
Gautam.
For I can understand devoting 2 hours after taking regular classes is a bit tough. Thank you so much, sir. And I need not to give any introduction of Ashutosh sir or Udit sir. You all are very familiar. We are, you all know them. So I will directly hand over to Ashutosh sir and Udit sir for the further discussion. Thank you so much. Meanwhile, if you have any questions, any clarifications, any doubt, we have an half an hour totally dedicated for that. So after 1.5 hours of the lecture, the next half an hour, 30 minutes, we have to only dedicated to clearing your doubts, question, clarification, and anything. You can write, you can ask directly, you can also write your doubts or questions or statement or clarification in the chat box too. So hope we will have a very good discussions. Over to sir. Thank you, sir.
Okay, thanks a lot, Gautam. So before we start, there are certain requests which I want to make that kindly follow the basic etiquettes of the online lecture. So we are there to answer all your questions. We are there to answer all your questions, any doubt, any issue. But you can raise your hand and you can, because you can easily imagine that there's around 120 and 30 people. So it will be very, very difficult. So I will suggest that kindly write down your any question which you have at any point of time. So we can answer that question then and there, or we will take that question at the end of the day. So depending on in what flow we are, where we are, so we will decide when to take the question. So the whole purpose of this initiative is to give you extra something, because constitution is the subject which is always relevant, and that is the subject which is the base of each and every subject which you are studying. So kindly don't take it as a subject, because when I started this subject studying in my library days, so I realized that it's a very, very easy thing, because generally this is how we are taught. But the more you go into the deep, you find that it is a very, very complex thing. And this thing can be easily understood that even after the passing of 70 years, still there are many questions which need to be settled by the Supreme Court of India or by the Parliament or the state legislature. So every day, whenever we are read the newspaper, you will find something or other thing related to the constitution. So the structure of today's lecture will be that Udit will be starting, and then I will come where, because principally this lecture is of Udit, because I will be taking a separate lecture on the Governor and the Election Commission of India. So principally this lecture is of Udit, but I will be coming and supplementing wherever is needed. So over to Udit.
Okay. So very good evening, Ashutosh sir, Gautam, and all the dear participants that are present. I would want to assure that I am audible to everyone perfectly. Am I audible to everyone perfectly? Yes. Okay. Thank you so much. So at the outset, I would like to offer gratitude to the society for having, started this initiative. And I recollect the day when the Constitution Society started with the first discussion on basic structure. That was in 2019, and I was a part of the panel. So somehow there is some connection that in the very pioneering event, the society happens to call me. So my risk-taking ability also increases with this, because there is more scope of taking risk in the first session. So I am very thankful to the society, and particularly Ashutosh sir. There are few new things that are new trends that are going to happen in this session, which are new for me particularly. First of all, I'll have the honor of taking a lecture along with Ashutosh sir, whom I really admire as a faculty. Second of all, I am not a person who uses PowerPoint presentation for taking classes, but in order to put my point well, and in order to make it a little more presentable, along with a little photographs and something, I have come up with a presentation that I'll be using that will involve the pointers of the discussion. So with this outset, I would like to begin. And one more thing, if it is left to your sense of introspection, that if you feel that the question is too urgent and it would miss its relevance if it is taken afterwards, then you can definitely come up with the question. Otherwise, it's a very humble suggestion that since we've dedicated the last half an hour for Q&A only, it would be better that you put down your question and send it across at the time when we are beginning with the Q&A, right? So let me start sharing the screen also. Are you all able to see a presentation at your screens? Okay. So yeah. Thank you guys. I've got the response. Thank you everyone. You can, thank you. So this is the first session of your Consti class. And since it's the first session, we'll have to lay the background of what a constitution is, what are the what is the meaning, what is the concept of the constitution. We'll discuss about preamble. We will discuss about constitutional governance. Constitutional governance was also taken up in the last class. Excuse me, whosoever is doing this, please don't do it. And it takes just a second for us to change this and disable all this. This is a learning format. Please don't disturb anybody. If you don't wish to be a part of it, you are happy to leave. Please don't do all this. Yes, so the topic for discussion is constitution, meaning and concept, preamble, constitutional governance. Historical evolution of Indian constitution is a part which I would request Ashutosh sir to take forward, because that is one aspect where I think he's much more competent than me to discuss with you. And the last part of it will be salient features of the Indian constitution. Now with this synopsis, I would like to start the session for today. Now, the slide that you see before you tries to expound what a constitution is. You might see, you might be a little perplexed also. There is an image which doesn't actually relate to anything serious that we are discussing. So I'll tell you what it is. So if we have to discuss what is a constitution, I think the basic understanding of it starts with that it's a charter of a state. When we say a constitution of a state, a simplest of answer could be charter of a state. Now, merely saying that it's a charter of the state which creates an state, which creates the organs that govern that state, which creates the mechanism or the framework that governs that state would not be enough. So, to put it correctly in few words, a definition is used in the slide that is before you. It says a supreme law which establishes, organizes, and empowers the government and determines how other laws are to be made and implemented. Now, this is a very comprehensive definition of what a constitution could be, but this too does not encapsulate everything which is bound to be there in a constitution. Now, first phrase that is used here is supreme law. Why supreme? Supreme particularly because the constitution constitutes a state. So every kind of lawmaking that is going to happen in this state is going to be subordinate to the constitution, is going to be confined in the contours or boundaries that the constitution fixes, or is going to be inspired or motivated by the way the constitution envisages it to be. So a supreme law is the first phrase with which it starts, supreme law in a state. And then it uses three terms: establishes, organizes, and empowers. A constitution does create the government and the organs of the government. The broad three organs of the government: legislature, executive, and judiciary. So, who is going to enact laws? Who is going to implement those laws that are enacted by the lawmaking body? And who is going to look at instances where there are any disputes with regard to interpretation of those laws? And who is going to look at enforcement of those laws when there is any remedy sought but not provided to a aggrieved party? So all this is establishing the government, establishing the model of the government. Organizing it would mean relating them, because a modern state could not operate in a straitjacket classification of legislature, executive, and judiciary. There has to be a thread which connects all three of them. There has to be a thread which connects and makes the whole phenomena called governance more alive. And by empowering, we mean that what functions are entrusted to them, what powers they have, all this. So broadly, we can say constitution is a charter of the state which establishes the state, organizes the government or the model of government in a state, and empowers the institutions that are made responsible for governance in a state. Now, I have used I've used the image of this jinn or genie, as you call him. Now, what is it reflecting? It is basically an analogy that I wish to draw. You must have heard about the story that a genie gives you three wishes when it comes out of the lamp, right? But the complete story of genie, as depicted in some tales that I read in the childhood, was that a genie is always obliged to the master who brings him out of the lamp. But the moment owner runs out of the wishes, the moment owner runs out of the orders that are supposed to be given to that genie becomes the devil and eats up the owner itself, right? That is why if you see in the slide, there is written the fourth wish. What could be the fourth wish? Because a genie gives you three wishes, and when you run out of wishes, it can turn into a devil. If he becomes a complete slave of yours, the complete agent of yours, and you do not give him orders, he would become your enemy. This exact analogy has to be put for a state. The constitution which creates a state in a way grants three wishes. It establishes the state, it organizes a state, and it empowers the institutions of the state. The three wishes are granted. But is that enough? Will the constitution be serving its true purpose by doing these three wishes? Or is there a fourth wish that is needed to be done? That is needed to be there in order to structure the governance properly. And there comes the role. I think somebody is raising hand. If you want to write something, you can use the chat. Yes, please, you can write in the chat box. So the fourth wish that needs to be there with every person who scratches the lamp is that the genie must be in control, that the genie must not ultimately become disastrous for him or her. And therefore, this fourth wish is in a way called constraint, or in the fourth wish, you may call it as constitutionalism. Some people call it constitutionalism. We will also go and read about that concept in a while. So, what I'm depicting here is the fourth wish. The fourth wish is constraining the powers of the government. It is not only important to establish the model of the government, organize the model of the government, empower them, it is also important to create a mechanism that constrains their power of the government. Now, do we see this in real sense? Do we see any constraint in the powers of the government in the real way? Yes. If you look at the Indian Constitution, I think you all must have read about Part 3, which is fundamental rights. Now, what are Part 3? They are one limitation, one very express limitation on the powers of the government. Legislature is the supreme body to make laws. Parliament is the supreme body when it comes to lawmaking. But can it make a law which abridges with the fundamental rights of the people? Can it make a law that has nothing to do with the division of power that is there in Schedule 7 of the Constitution? No, these are express limitations that are put. So the fourth feature that I would want to add in the definition of a constitution is limits power or constraint power. So organization of power or establishment of state, empowering a state comes along with providing for the constraint or providing for the limitations on the powers also, right? I hope if we add these four features of establishing, organizing, empowering, and constraining or limiting the powers of a government model or institutions of the governance, then we get a very comprehensive definition of constitution. But there are certain subtle things that are also done along the journey of constitution making that we'll discuss in a while. So these are the broad features. This is the broad agenda, what we call a constitution. And this is the broad depiction, the most comprehensive one possible according to my understanding that can define a constitution. Now, here in the slide, I have used a few types of constitution that are normally understood when we start the preliminary study about constitutions. We'll broadly look into it. I have mentioned here written, unwritten, federal, and unitary. Now, according to the model of the state that the constitution is creating, according to the model of governance it is creating, we have different types of constitution also, like the written constitution. A written or codified constitution, example may be American Constitution, which is the oldest constitution of the world, or the Indian Constitution, the lengthiest constitution of the world. So written constitution in a document lays down the whole model of governance. In a document puts across the organs of the state, the relationship between them, their powers, their responsibilities, and the mechanism of the government. Whereas an unwritten constitution is not in form of one document. The kind of constitution making exercise that happens over a document in written constitution, the same exercise doesn't really for an unwritten constitution. An unwritten constitution prevails in the form of several instruments, conventions, precedents. It is a byproduct of multiple legal instruments. So one big example is the British Constitution, which is not written formally as a constitution, but still it has a whole model of governance. And you want to trace the beginning of it, you may go back Magna Carta. From there, we have number of instruments, number of legislations passed by the parliament, number of judgments of the courts that have interpreted the constitutional positions, and all that cumulatively forms what we call as constitution. So a written and unwritten constitution basically differs in the trait that a written constitution gets created as a document after doing a whole exercise of establishing a whole new state or establishing a whole new model of a state, where unwritten constitution is a byproduct of several instruments, precedents, conventions, legislations, treaties, several instruments. Now the other is federal and unitary. So you know that there could be several models of governance in a state. There could be a model where one government at the central level or the union level has a centralized power. It makes all laws, rules, regulations, and it gets implemented throughout the country, across the territory. And there could be another way of doing it where there are different provinces or units or subunits which are empowered. The power is divided amongst them, and those bodies or provinces are empowered to make their own rules, regulation, carry on their own governance. So it's a sharing of autonomy in governance. It's a stake in governance. Like American Constitution, it came up as a as a culmination or union of several states that were too different and that were not ready to give up their autonomy. So given certain features, certain things like defense, currency, and other things, they have found a way to solve their own problems in their own way. Another example is Indian Constitution, where again it is union of different states, different provinces that came up, joined together, and made the idea as one unified India. However, still there is a huge diversity, and therefore there is the need to share powers, and therefore we have this Schedule 7, wherein there's division of power in union list, state list, concurrent list. So what matters are at the national level, you could think of defense, currency, economy, all those big matters of foreign relations in the hand of union, and other matters that are specific to local interests in the in the hands of state, law and order, etc., etc., and certain matters which are which are of equal importance, like labor welfare, marriage, etc., etc., are in hands of both of them. Both of them can legislate over it, right? So this is the broad division of federal and unitary constitutions. Now, there are certain words that have been used at the end of this slide. One is constitution, and the other word is constitutional law. Is there a difference between these two? I mean, you can quickly use the chat box to respond. Do you see a difference between these two, constitution and constitutional law? Yes, there's one person who responds yes. So yes, there is some difference. Now, constitution is that particular document. If we talk about India, the constitution of India is the text of the constitution which has laid down the whole manner of governance inside the country, right? But constitutional law is rather a bigger phenomena. Constitutional law is of a little wider ambit. If I happen to ask you, you all must have in your study of constitution came to know about a very, very celebrated and landmark judgment named as Keshwan Bharti, state of Kerala. Yes, you've heard of this judgment? Do you anywhere find the word basic structure in the text of the constitution? Do you anywhere find or text basic structure in the text of the constitution? No, you don't find that. But can you claim, okay, we've got responses, you can wait. Can you claim that your understanding about Constitution of India and its law is complete without reading Keshwan Bharti? I mean, if we deduce Keshwan Bharti from the constitutional governance, can we say our understanding is complete? But Keshwan Bharti is not part of the constitution. Basic structure theory or basic structure doctrine is not part of the constitutional text as such. So constitutional law is rather a wider ambit, which not only includes the text of the constitution, it also includes the interpretation of those texts, the various conventions, various theories, the various um, the various interpretations that have come through the courts and which have contributed in the growth either positively or negatively towards that particular constitutional mechanism, right? So constitutional law is rather a bigger phenomena than the term constitution as such. Now there's again use of two terms here, constitution and constitutionalism. Two terms are used. Again, I would have to ask you, is there a difference between these two? There is, certainly, yes. like I mentioned, that a constitution may establish, organize, and empower the institutions of the government, but may sometimes forget to control or constrain their powers, which ultimately might be disastrous, have a counterproductive effect towards the people and their rights, right? So constitutionalism is a philosophy which believes in the idea that the powers of the government must be limited by the law and the constitution. The powers of the government must be limited by the constitution, or rather you can call it, it is an idea of limited government. That is just one facet of its understanding, but the idea of limited government means the powers of state are not absolute. The powers of state are limited. So it may so happen that we have a constitution, but not a fair sense of constitutionalism in a state, right? The old German constitution, it was a text, it was a government mechanism, but it did not have the spirit of constitutionalism. In fact, it was counter to what we call constitutionalism. And there could be a state where we do not have a formal written constitution, but we still see traits of constitutionalism, like in Britain, right? So it may so happen that constitutionalism is rather the byproduct of having a constitution. Constitutionalism, ideally, generally, would be a byproduct of a limited government, which is limited by the express and implied terms that are put in the constitution, and that are imposed by courts over the years, right? So constitutionalism is a philosophy which believes in the idea of limited government, or a government having check and balance over its powers, right? So yeah, I think we are almost through with this slide, so we can move to another slide now. And I think this is a very, very important slide that I wish to convey to you. A constitution, and I would use the word a modern constitution, the constitution that have come in the past 50, 70 years. Many constitutions across the globe have come in this time. And not only that, a constitution is a memoir of aspirations. A constitution is a document of hope. A constitution is a document of where we want our state to reach. Abhishek will reply to that comment possibly later. I mean, this could be one perspective of looking at things, but there is a different perspective also. So we'll discuss it in the last half an hour. Okay, Abhishek? Yeah. So if you see, I have used this phrase "hum dekhenge," which I mean recently a very controversial nazm by Faiz Ahmad Faiz, where the whole idea behind this is that they are aspiring of a particular moment, they are aspiring of a particular order, they are aspiring of a particular model, they are aspiring or hopeful of a day when there will be justice, when there will be equality, when there will be liberty of thought, and several facets. So when we draft a constitution, it is a futuristic document. You can see the word futuristic used here. Why we say it is a futuristic document? Because it wants to reach at a certain place. It creates a state, and it creates the dream for that state. It gives the target for that state. It aspires the state to become something, and that is why I have called it a document of aspiration. If you look at the preamble of the constitution, if you look at the directive principles of state policy, which is chapter 4 in the constitution, and in fact if you look at part 3 also, which is fundamental right, you would come to know that this is the document of huge aspiration. The kind of governance that we were in the British regime, the kind of struggle that we made for independence, and the kind of sacrifices that we've given for independence and for securing a state. Now this is what we want our state to be. Now the constitution makers in some parallel universe must have been singing the same rhyme of lazim hai ki hum dekhenge. They must have been envisaging a state where you can look at the preamble and see justice, social, economic, political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, fraternity, assuring the dignity of individual, and unity and integrity of nation. I am not sure whether we have achieved all the agendas, all the aspirations of the constitution makers, and I am not sure whether we would ever be able to achieve all of them at a given instance. But it will keep aspiring, it will keep motivating the generations, it will keep motivating the institutions that are made under the constitution, it will keep motivating each individual, each citizen of the country to work towards these aspirations, to reach to a certain level, to represent what the state stands for, right? That is why I call it a document of aspirations, a document of hope. I have used the word futuristic, and yes, constitutions are futuristic documents because they lay down a model of a state and they aspire to reach at a model of governance where there are some traits like justice, equality, fraternity, uh, freedom, and all those things, right? It's a revolutionary document, and this I am saying particularly in context of Indian constitution. And while discussing salient features, I've kept one particular trait as revolutionary, but I'll just give you little inference before we discuss there elaborately about it. If you just happen to look at article 17 of the constitution, which is abolition of untouchability, if you just happen to look at article 23 and 24 of the constitution, which is rights against exploitation, and if you just happen to look at article 38 and 39 of the constitution, which are directive principles of state policy, you would not be able to deny the fact that it is a revolutionary document aspiring to finish untouchability, to do away with untouchability. You would not find a similar provision in any other constitution of the world. Revolutionary in the sense that we want to do away with the historical injustice that was prevalent, the discrimination on the basis of caste, the discrimination on the several other bases that was prevalent, and the connected evils that used to be prevalent in the society with those things are to be done away with. And this takes courage, this takes valor. So, this is a revolutionary document in some way. And lastly, I've used welfare oriented. I broadly wish to convey that most of the modern constitutions have a lineage towards welfare of people, have an inclination towards welfare oriented approach, particularly Indian constitution. Indian constitution is an ultra welfare oriented document, where the focal of constitution governance is the individual, where the focal point of constitutional governance is to benefit the individual, develop the personality of an individual, and help the individual grow to a certain extent with all amenities at the hands of the state. Now we'll deliberate on the revolutionary and welfare oriented aspect a little later also. So this is also one of the functions of the constitution: establishing the model, organizing the model, empowering the institution, constraining the powers of the state, and giving hopes and aspirations for the future to reach at a particular place, to to guide the future generations towards certain ideals and inspirations. Right? This has been put down by the courts in their judgments also. I will be referring to some aspect when we refer to preamble. So the last part is what the state stands for and what it wishes to achieve. So the ideals for which this state is being created and the ideals which the state wishes to achieve. That is why I, in with full conviction, state that it is a document of aspirations also. Okay. Now let us move to the next slide. Yes, preamble of the Indian Constitution. Now you all have multiple times must have gone through the preamble of the constitution, and you all must have noted certain things. We'll be discussing them in a while. It is largely being inspired by the constitution of United States of America, and this slide is also this slide also corroborates with the conviction that I was stating. If you read even the preamble of the US Constitution, it says, "We, the people of United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for a common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution of USA. So it's not this aspiration and this hope is not only reflected in Indian Constitution. This is the trait of all futuristic documents which we call Constitution, that they have a aspiration to reach at a certain place. Now further discussions regarding the preamble of Indian Constitution are being made in the next slide. So I'll be just reaching there. Yes. So what is a preamble? You must have read several statutes by now. You must have read contracts. You must have read some procedural laws also. And you must have seen that every law has a small preamble attached to it, which tells the object and purpose for which the law is brought into force, right? So preamble basically is a preface or an introductory part of any law or any policy that defines what is the agenda, what is the objective this law and policy seeks to achieve, right? Now, is I would want to take the discussion to this part where I have mentioned this fourth point, importance of preamble in constitutional statute versus an ordinary statute. Is the importance of preamble similar for an ordinary statute and for a constitutional statute, by mean the Constitution of India? Is it the same, or the level of importance that needs to be attached to the constitutional statutes preamble must be a little more than the ordinary statute? We'll have to see. There was a judgment of the Supreme Court of India which declared that preamble is not a part of the Constitution. If any sense has to be made out of the objects of the provision or the to resolve any disputes in the interpretation of the Constitution, it is only the text of the Constitution that has to be referred. But this judgment of Berubari got overruled by Keshwan Bharti judgment, which laid down that preamble is very much a part of the Constitution. It has put up the ideals of the state and the Constitution, which is the second point here. And it has said in Keshwan Bharti that it embodies all the ideals and aspirations for which the country had struggled during the British regime. So the preamble is very much a part of the Constitution. Now the question comes, if it is a part of Constitution, how important it is in interpreting the Constitution, how important it is in knowing or solving the difficulties in knowing the meanings of under the Constitution. So the courts in Keshwan Bharti and further more judgments have said that whenever there is a dispute, there is a inconsistency, there is an ambiguity with regard to application of certain provisions or determining the meaning of certain provisions under the Constitution, then we have to revert to the preamble to know which side we should incline towards. We have to lean towards the ideals for which the state is made. We have to lean towards the ideals for which the Constitution is made. We should call the preamble as the key to open the minds of the Constitution makers. I would want you to put this phrase in your notes wherever you are putting your notes, because this is a very important phrase. This is used by Supreme Court multiple times in context of the preamble, that it is the key to open the minds of the Constitution makers. That means that in every law, the courts have to track the legislative intent. They have to know what the legislature actually envisaged before creating this law. So therefore, preamble stands as a key to reach to the intent of the Constitution, to reach to the ideal of the Constitution, to reach to the minds of the Constitution makers, what they had in mind while conceptualizing this vast document, right? And preamble also, if you note in the previous slide, it starts with the text, "We the people of India." So it is also reflecting on the source of the constitution. It is also reflecting that where does the true source of power lies. If we, the people of India, have given to ourselves this constitution, then who is the boss in this whole scenario? Then who is the body? Who is the entity who is the repository of whole power? It is not the constitution. There is somebody above the constitution who is creating the constitution and giving to themselves this constitution, and this is the people of India. So preamble is doing few fundamental things for us. It is telling us the ideals and aspirations of the state and the constitution. It is telling us, it is helping us to reach the legislative intent for which this constitution stands. It is also letting us know the source of the power, the source of the constitutional authority, which is the people of India. And it is often used by courts when they are stuck in a situation that now what should be the proper interpretation, where they should lean towards. So the preamble helps them in guiding towards the legislative intent. To choose a side, they may be motivated by the preamble. And the point which I started with, that importance of preamble in the ordinary statute versus constitutional statute, it is being stated in Keshwanand Bharti judgment only, that the importance that should be attached to the preamble in the constitutional statute must be far, far more important than the ordinary statute, because because the impact of a constitutional statute is so much that it may impact the ambit of all other laws that are made, all other mechanisms that are created under the constitution. So therefore preamble in effect will have far more importance than a preamble in a constitutional statute or in the constitution of India will have far more impact in that context. Okay, now there are several terms that are used in the preamble of the constitution of India. Five of them are very famous, which you must know all the time. Which says that we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. These five terms are very important. I wanted to emphasize on all these five, which I'll broadly do, but I have been informed by the committee and looking at the event, there is a specific session that is dedicated for these five words, these five features in all their political context and legal context, which will be, I think, tomorrow. So I will not lay too much emphasis on these terms, but I would want you to lay as much focus on these five terms: democratic, sovereign, socialist, secular, democratic, republic. There are two terms, socialist and secular, that were not part of the original draft of the constitution, that were added later in the year 1976 through the 42nd amendment. Now, while we discuss those two traits in the salient features, I'll have few questions for you also, and we'll discuss it there. Okay. So, but broadly to mention, I'll speak about all five of them. Sovereign means that you are almighty in your domain of governance. There is nobody who is whom you are subservient to while governing, while having the authority of the state. So when India becomes sovereign, it does not have to bow down before any other entity, body, country, and before making a law, before taking a decision as to governance, right? Uh, After Indian Independence Act of 1947, we were still dominion state. That means we were under the authority of the British Crown. But the day constitution came into force, we became sovereign, which means that we are no more limited by any other external power. We are almighty by our own sense, right? That's the first thing. Second is democratic. Democratic means the people have a stake in governing themselves, that the people choose the laws that are meant to govern them, or indirectly choose the people who make laws which ultimately govern them, right? To have a stake in the governance is democracy, right? So sovereign, democratic. Socialist is leaning towards the welfare of masses. We'll see a few provisions to prove this point. Secular means not having a specific religion of the state and also giving freedom of religion to each individual to choose whether they want to have a particular faith or they do not want to have any faith. This is a completely a private matter, not to be decided by the state. So this is secular. And the last part is republic. Republic means that the head of state would be elected. Now the head of state in India is the president. So, and president is elected, though indirectly by us, but a president is a elected authority, and it is not this authority is not filled out of any legacy, out of any hierarchy, or out of any monarchy. It is an elected head. That is called republic. So these are 5 instances. The details will be discussed. I think a whole session is there for this, and we'll reflect on some more elaboration when we'll deal with the salient features. Okay. So having talked to you about preamble also, there are only 2 broad aspects left for discussion. One is the uh, historical background of the Constitution of India, and the second is salient features. Now, before, if we take up salient features, it won't be proper because historical background must be conveyed before. And for that, I would definitely require Ashutosh sir to take lead. So I'll just present very briefly about the few milestones that you must pay attention, all the students, while you read about the historical background. There are certain events, there are huge amount of events that are responsible for historical evolution of Indian Constitution. But if you want to lay emphasis on few major ones, then the highlights are Government of India Act 1919. This is the act passed by the Parliament of UK for engaging, for giving more stake to Indians in the governance of India, and also for establishing the bicameral legislature model that we have today, for establishing the public service commissions that forms the bureaucracy of India. Even today we follow this model. So these are the few broad developments under Government of India Act 1919. Government of India Act 1935 is a substantial contribution to the constitution that we have today, the federal setup, the office of governor, the ordinance making power, and by far, if in spirit you see, almost 70% of it comes from Government of India Act 1935. That is why we had a backdrop while we started drafting constitution. The Indian Independence Act of 1947, which came in pursuance of the Mountbatten Plan, which divided the whole of territory of British India into 2 territories, India and Pakistan, and both were made 2 dominion states until they come up with their own constitution, and the constituent assembly of both the nations, both the dominion nations, were empowered to make a constitution for their own governance through this Indian Independence Act of 1947, and therefore it is very, very important. And last is the role of Constituent Assembly, that is majorly from December 1946 to January 1950 until the Constitution came into force. This phrase, I think, would be best dealt by Ashutosh sir. So I would now request Ashutosh sir to deal with it, and then later we'll go to salient features.
Okay, thanks a lot, Udit. It was a very, very enlightening lecture. So basically, Udit have given a very good background about the whole structure of the Indian Constitution. But as we know that in India, we have this some aspect of lawmaking from the ancient time also. So for example, if we read Kautilya's Arthashastra, so I will recommend you to go through certain parts of the Kautilya Arthashastra because of the simple reason that it will give you certain structure. It will give you certain structure that what was the structure of the governance way back. Similarly, if you read about, generally people say that Vaishali is the first republic in India. Vaishali district that is there in Bihar, it was having a first, recognized as the first republic in the India during the ancient time. So we have certain basics of the governance from very, very ancient period of time. But no doubt, the moment the Britishers came, we have seen certain structural changes in our legal system. And the biggest, I will not go from the 1600 charter and all those things, but I will mention one important part, that is 1858 charter, because that is the time when India came directly under the control of the Britishers, because before that we were under the control of the East India Company. So after the first freedom struggle, which happened in 1857, so the Britishers realized that if we have to effectively control the Indian territory, then we cannot rely completely on the East India Company. So we have to take the complete control, and they transfer the whole power from the East India Company to them. So effectively, if we see, then India come under the effective control of the Britishers from 1858 onwards. Thereafter, certain changes were made in 1909, 1909, 1935. So we got a chance to form our own government. But the problem, there was one statement, very famous statement given by a person when he was a minister in the state of Madras during the British time. He was a minister, so he used to say that about his power, that I am a minister of industry, but without any factory. I am a minister of agriculture, but without any crop. I am a minister of finance, but without money. So it shows what? It shows that Britishers gave us certain power, but at the same time, they have a complete control over the major thing. So ultimate authority to decide about the things were left with the Britishers. There are certain powers given to us, but that is not the effective power which is given to us. So we have the ministers, but generally they cannot exercise their power without the consent of the British people, or the major power were under the control of the governors, who directly comes under the British authority. But the significant change happened in the course of the thing is the your Indian Independence Act. Before that, what happens, there was a cabinet mission plan which came to India, and this lays a groundwork of the Constituent Assembly of India. So as we know, Constituent Assembly of India met for the first time on 9 December 1946.
Sir, you are not audible. Ashutosh, sir,
Okay,
somehow you are not audible. Yes.
I'm audible
Now you
now.
are. Yeah, yes, you are now audible. Yes.
Okay. So I give you a brief thing. What I was telling you is that in India, we have certain legal framework from very ancient time. So especially if we start from the Kautilya's and everything. So kindly have a look at the Kautilya Arthashastra. Similarly, Vaishali district in state of Bihar, it is recognized as the first republic. So we have certain governance structure. Then Mughals come, they have certain different structure. And later on, finally in 1858, India came directly under the control of the Britishers. India came directly under the control of the Britishers. Thereafter, the Britishers started giving us certain powers through 1909 Act, 19 Act, 35 Act. So we have government which was formed by us. But if we talk about the power of the ministers and power of the government at that point of time, ministers used to say that I am a minister of industry, but without any factory. I am a minister of agriculture without any produce. I am a minister of finance without any money. So what does it show? It shows that complete control still is vested in the Britishers. The complete control is still vested in the Britishers. So we have limited way of governance, but at the end of the day, everything can be overruled by the British system. Is it clear?
Yes.
The significant change which happened, on which I want to focus, is the Constituent Assembly. So we have a CRIPS mission, cabinet mission, and cabinet mission plan laid down the framework of this Constituent Assembly of India. Now you have read the preamble, we the people. Who have drafted this constitution? So we say that we the people are the source of this constitution. But Mahatma Gandhi gave a statement when Constituent Assembly started functioning. Mahatma Gandhi gave a statement. It is like this, I'm quoting, it is no use declaring somebody else's creation a sovereign body. So Mahatma Gandhi used to say that it is no use to say somebody else's creation as a sovereign body. Why he used to say? Because at that of time we are under the control of the Britishers. So he is saying that why you are saying that Constituent Assembly is a sovereign body? Why you are saying that this assembly is a sovereign body? Because he is saying everything is done under the British rule. So why we are saying that it's a sovereign body? So he is raising a big question mark over the whole Constituent Assembly. Gradually what happened, by the Independence Act of 1947. So this question of sovereignty of this Constituent Assembly was resolved because the Britishers transferred the power to us. So through the Indian Independence Act of 1947, we got the power of independence and all those things which are mentioned in the Act. When we were drafting the Constitution, we have a huge problem because generally, whenever we make a nation is based on certain uniform factor. Yes? Do you agree with this? Generally, a nation is formed on what? Either on the basis of the language, or on the basis of the religion, or on the basis of the culture. So there should be some uniform factor. Otherwise, it is very, very difficult to bind a nation. Because at the end of the day, you should be having certain uniform factor to bind the nation. India was missing all those things. Neither we have one religion, nor we have common language, nor we have common culture, nor we have common food practice. So you cannot name a single factor which is common to us. Even now, if we go and move 5 kilometers ahead, the culture will be different, the food will be different. So India is having an altogether different challenge in framing the constitution as compared to any other nation. And at the same time, the partition of India have played a very, very important role in the outcome of the Indian constitution. Because of this partition of the Indian constitution, we have a strong union. Because we realized that if the student union will not be strong, then there will be a huge problem of unity across the nation. Because as I told you, there is no unifying factor. So this is the reason why you will find, and you will see in coming lectures also, that Indian constitution is biased towards the union. I'm using the term bias because of a simple reason that if you weigh the power between the union and the state, union is having much more power. For example, if we compare the list, in USA, they have only few subject matters in the union list, rest of the subject matters in the state list. In India, it is reverse. We have more subject matters in the union list, less subject matters in the state list. Even on the concurrent list, what happens? Both can make the law, but at the end of the day, the union law will prevail over the state law. As we have seen during the COVID time, every state is bound to follow the union government guidelines. So if you remember, in around April or May, union government said, when we were unlocking little bit, that you cannot open the barber shop, you cannot open the restaurant. Kerala government said that we have less number of cases, we will open the barber shop, we will open the restaurant. Then there was a letter issued by the Secretary of Government of India that you can't do so. You are bound to follow us. So this clearly shows that Indian constitution is biased towards the union. And the reason is very obvious. The people have seen what happened during the partition. So in my opinion, if the partition haven't happened, we may have a different constitution. If I come to Constituent Assembly of India, so at that point of time, it was thought that how you will constitute this Constituent Assembly. What is the process? Because you are saying that we the people of India are doing this. But whether we the people are involved in the process of the drafting of the Indian Constitution or not, that is a big question. Because if you are not involved in the drafting of the Constitution, how can we say that we the people of India drafting this Constitution? We are the source of the Constitution. So we have two options, either to go for election and constitute this Constituent Assembly, but it will take a lot of time conducting the election, then the people will be there, then the Constituent Assembly will be formed. So it will take a lot of time. So therefore, it is thought that we already have provincial assemblies, which is elected by the people, although with a limited adult franchisee, because only 20% of the population was able to part in the elections. So we thought that we already have many provinces which have the assemblies. So we will ask the assemblies to send the people to the Constituent Assembly of India, just like what we are doing right now for the Rajya Sabha, the Council of State. So if you see how the people come to the Council of State, every state send a prescribed number of MPs to the Rajya Sabha. So if you see the Schedule 4 Indian Constitution, you will find which state is sending how many MPs to the Rajya Sabha. So we thought that if we go for the direct election, it will take a lot of time. And we wanted to get this constitution as early as possible. So we decided that we will go for this indirect election. And thereafter, this Constituent Assembly was constituted. Initially, it was having approximately 400 people. But in the meantime, what happened? The partition happened, and approximately 100 people who were there in the Constituent Assembly on 9 December 1946, they became part of the then Pakistan. So initially, at the end of the day, it's a work of around 300 people. But among these 300 people, I want to take name of certain specific people, because generally we think that the constitution is the outcome of the Dr. Bhimrao Ambedkar. No doubt he has played a very, very important role. Our first Prime Minister, he has played a very, very significant role. Sardar Vallabhbhai Patel, very important role. Maulana Abdul Kalam Azad, important role. Dr. Rajendra Prasad, very, very important role. But we forget to mention one person. Can anyone guess, apart from these five, who is instrumental? Can anyone guess? Can any person guess? I told the name of Dr. Ambedkar. Oh, yes, B.N. Rao. So B.N. Rao was a very, very instrumental. So he was a constitutional advisor to the Constituent Assembly of India. He's the most, in my opinion, his role is not less than Dr. Bhimrao Ambedkar. Why? Because he was the person who presented the first draft of the Indian Constitution. And later on that draft, we started modifying and working on it. So we added something, we removed something. But as a common perception, if you have something, a draft, then it's easy to work on it rather than writing something completely new. So this person, B.N. Rao, he went around the world. He went around the world asking the people of different countries that what is the experience of them of their own constitution. So for example, he went to the USA. There he met then Chief Justice of the USA Supreme Court, Felix Frankfurter. So he was asking that, as a Supreme Court judge, what is the worst thing you find in your constitution? So he's saying that the worst thing which I found in my constitution is the due process clause. In USA also, they have a right to life, and there they have due process clause. So he asked why. So he's saying that we are flooded with the cases because every person is challenging the law on the basis that it is violating the due process clause. So every person went and said that this act is violating the due process clause. So we are flooded with the whole case laws. So I will suggest you not to go with this due process clause in your Indian constitution. So B.N. Rao came back to India and he told the Constituent Assembly that this is what I also think. And this is the reason why we didn't pick this due process clause and we went with the term procedure established by law. Because when we were drafting the constitution, there was another country which was drafting the constitution, that is Japan. So after the World War, Japan was drafting their own constitution under the supervision of the USA. So they have this procedure established by law in their constitution. So we took this term from the constitution of Japan. And of course, by the time Menka Gandhi judgment came, the interpretation changed. So his role is very, very important. The other beauty of this Constituent Assembly was that, because as I told you, there are so many conflicts, so you cannot resolve all the conflicts. So what they have done, they have left this conflict to be decided in by the future. For example, take the case of language. On language, the whole Constituent Assembly was divided. Language was one of the topics on which the maximum time was devoted by the Constituent Assembly. After language comes the property. So you can easily imagine the divided house, because the people were wanted, of course, citizenship also. People wanted that Hindi should be recognized as a language, but the southern part was completely against it. So what is the way out? The way out by the Constituent Assembly to appease all the sections, that they are saying that we will recognize Hindi as the official language, at least for the next 15 years. English will also be considered as a official language. Clear? So they left this thing to be decided future, because if they have decided at that point of time, then in my opinion it may create a big issue of conflict, and we are just getting independence. So it is better to avoid the conflict. Let us move ahead, and later on we will see that what could we have done to this contentious topic. Same is related to the whole of the DPSP. For example, a very interesting debate on the cow slaughter. So many people wanted that prevention of the cow slaughter should be in the fundamental rights chapter, and they were giving their argument on the basis of their religious affinity, that this particular animal is very, very sacred to one particular religion. But there was opposition from the other side. But then one member said that why we need to prevent this cow slaughter, not because of religious ground, but on the ground of the purely economic criteria. What is the ground of the purely economic criteria? Why? Because at that point of time, and even now, cow is very, very important for the rural life. So it is the integral part of the rural life. So the argument shifted from religious affiliation to the economic viability. And this is how he was able to convince the people that at least we should have this in the DPSP. And later on we will decide, and we will left it to the states whether they want to implement it or not. At the same time, take the case of the UCC. Again, it's a contentious topic. They have left it for the future. So if you read the whole Indian Constitution, you will find that they have played very smartly. So they have left all the contentious topic future. They have left all the contentious topic for the future. And in a way, it's a very, very good thing to do. This, when Pandit Jawaharlal Nehru presented the objective resolution of this Constitution, which later on adopted as preamble of the Indian Constitution with little bit of modification. So he was trying to convince us that we want a unique Constitution which will be for everyone, there will be equality and there will be everything. But at the same time, there was a very famous line which is given by a person, K. Hanuman Thaiya. He said that he's saying about the Indian Constitution, so kindly listen. So he's saying, we wanted the music of Veena, we wanted the music of Veena or sitar. But here we have the music of English band. So he is saying that we wanted the music of Veena or sitar. So Veena or sitar is resembling India. But he is saying at the end, what we got under the Indian Constitution is we are getting something which is completely not peculiar to the India. Why he is saying? Because the topic of language was there, which is not answered. Similarly, the topic of the preventive detention. So most of the freedom fighters, most of the people who are drafting the Constitution, they themselves are the victim of the preventive detention. Yes, but at the same time, in India, we have retained this concept of the preventive detention from 22 clause 4 to 7. So he is saying that what is the difference we are going to make? That is the law during the British time, and that is the law which we are continuing with the in independence also. We are still continuing with the English language, and English is considered as a baggage of Britishers. It is considered as a baggage, a symbol of that we were a servant of someone, technically. So he's saying that why we are still continuing with the English language. So he's simply saying that we are drafting the Constitution, you are giving us the freedom of religion and everything, but at the same time there was a big question mark that why you are not making the DPSP enforceable by law. Why you are wasting 15 to 16 articles in the Indian Constitution at the end if it is not enforceable by law. So to this question, Dr. Bhimrao Ambedkar gave a very famous reply that fundamental law are enforceable by court of law, whereas DPSP are enforceable by court of people. Why he is saying so? Because DPSP talks about the welfare of the people. And if the government ignores the welfare of the people, then the people will get a chance to vote them out. Because after every 5 years, there will be general election. And why they will wait for the 5 years? Right now in India, after every 3 or 4 months, there is some or other state election. So people can send a message to the government that, see, we are not happy with your policy. So if you are ignoring the DPSP, then at the end of the day, it's a big, big risk which you are taking. So Bhimrao Ambedkar used to say that this is not the reason that why we are not making it enforceable. The reason is that we don't have the resources to make them enforceable. and gradually with the passage of the time, we will make DPSP enforceable by law. And we have seen that gradually some DPSP have become part of our fundamental right, either through the decision of the court or even by the act of parliament. So Ambedkar was right in this particular assumption that gradually we will implement most of the DPSP. Other which is very, very unique about this whole Indian Constitution is that how to read it. So generally we start with reading Article 1, but I will suggest you to start reading from the backwards. So I will suggest you to read the Article 393 first, Article 394 first, because if you read IPC, if you read contract, in the beginning in the section 1, you will find this act will be known as so and so, it will come into force from so and so date. Do you find the same thing in the Indian Constitution? Do we find the same thing? If someone asks you from which date the Constitution of India came into force, what will be your answer? Which date the Constitution came into force? So what will be your answer? Jan or 26th November? So where it is written? It is written in Article 394. So if you read Article 394, Preamble is using the word 26th November 1949. But if you read Article 394, you will find the answers. It will say that this article along with Article 5, 6, 7, 8, 9, 10, 11, Article 60, 324, it will come into force at once. At once means 26th November 1949, and rest of the Constitution will come into force from 26th Jan 1950. But if the question comes that what is the commencement date of the Indian Constitution, the answer must be 26th Jan 1950. So this is mentioned in Article 394 at the last. Same way, what is the title of this Constitution? So that is mentioned in Article 393. Is it clear? So kindly keep in mind 393 and 390, because generally what happens, we as a student and we as an academician also, generally we don't go beyond Article 368. Or with our excitement, we will go till Article 370. But there is a Constitution after that also. Of course, most of the articles have been repealed now, but still there are certain things which is very, very important. Lastly, I will tell you, see the dilemma that Constitution came into force on 26th January 1950, and the first amendment to the Constitution was brought in the year 1951 itself. Here, first amendment to the Indian Constitution was brought in the 1951 itself. And who is amending the Constitution? Any idea who is amending the Constitution? Who amended the Constitution? The first amendment? State reorganization happened in 1955-56. Who is amending this Constitution? When we have the first election in India? First election happened when in India? 51. It started in 51 and ended in 52. So then who amended the Constitution in May 1951? Because we don't have the parliament. Of course, Jawaharlal Nehru, but how? How can Supreme Court amend the Constitution? Because we got the first parliament in 1952 technically. Constitution is amended in 1951. So who is amending this? Okay, good. So Constituent Assembly, there was Article 379. There was Article 379 which say that till the time we constitute our first parliament, Constituent Assembly will act as an interim parliament. So Constituent Assembly will act as an interim parliament. So this Constituent Assembly is bringing the first amendment. And see, the same people who have drafted the Constitution 1 year back, now the same people are amending it. The same people who drafted the Constitution a year back, now the same people are realizing that we have made certain mistake. We have to rectify it. Why this happened? Because of the certain judgments of the Supreme Court, especially the judgments related to the freedom of speech and expression, the judgment of Champakam Dwai Rajan versus State of Madras, which brought the first amendment and we added Article 15 Clause 4 into the Indian Constitution. Same thing happened. We added more ground of restriction in 19 Clause 2. We added Article 31A, 31B, 9 schedule into the Indian Constitution. And see the dilemma that the Dr. Bhimrao Ambedkar, who used to defend all these things when he was a member of the Assembly, right now, he was a great admirer of the freedom of speech and expression when he was there in the Constituent Assembly. The same Dr. Bhimrao Ambedkar brought this first amendment to the Indian Constitution, which restricted your freedom of speech and expression in a much more wider manner by adding more and more grounds on restriction in Article 19 Clause 2. So this shows that no constitution will be static, it will keep evolving. And we have seen that in the past 70 years, we have amended more than 104 times, as compared to the USA, which in the past to 30 or to 20 years, they have amended the constitution, I think not more than 30. So their amendment is not more than 30 and our amendment is more than 100. So there are lots of things which we have to discuss. So we will discuss it during the coming lecture. So I don't want to repeat the same thing which will be repeated by the other people. So over to Udit, because we have to take questions also at the end. So I want to give ample time for the questions also.
Okay, thank you so much, sir. Thank you so much. Before I move further, I would just point out that few people have this misconception that Mahatma Gandhi was also part of the Constituent Assembly, because this was reflected from some responses. Actually, he wasn't part of the Constituent Assembly, nor was Jinnah part of the Constituent Assembly. These two members were not there. Okay. Yes. Now let us come to the final part of discussion for today. This is salient features of Indian Constitution. Now, I think that the spelling of salient has gone wrong, so kindly ignore that part. So in discussing salient features of Indian Constitution, let us look at few things, and obviously it will reflect on few things that I mentioned are coming from the preamble itself. So first thing is sovereign democracy.
Udit,
I think this could be one phrase in. Yes, sir.
Udit, I will suggest you to kindly leave first, second, and third because we are covering it tomorrow. So we can start with rule of law and independence of judiciary and judicial review. Because the first three is going to be discussed tomorrow.
I'll just take a second on third one. Third is socialist and secular. I told you that these two terms, socialist and secular, were added in 1976 through 42nd Amendment. But I said I'll have a few questions to you. So I would ask, was Indian Constitution not socialist and not secular before 1976? What do you think? Look, there can be two angles from which you can analyze whether a constitution is secular or not. One could be that does it have an official religion of its own? Does it declare a particular religion to be its official religion? So did Indian Constitution declare any particular religion as an official religion? First of all, no. So that's the first. Second is it gives freedom of religion to everybody. And Article 25 was very much a part of the Indian Constitution, right? Freedom of religion means you can choose a particular faith, and under preamble also you have the phrase liberty of thought, expression, belief, faith, and worship. So that means you can have faith, you can have no faith, you can have multiple faiths. It was all there. So it was secular, and but times need some more emphasis to be paid or to certain phrases. So possibly that was the idea. The other term is socialist. Indian Constitution, I'll just give you one instance that I gathered from an series that is there on Rajya Sabha TV called Samvidhan. From there, when the Constituent Assembly members were actually going to meet on 9 December 1946 for the first time to convene this assembly, because our freedom movement was greatly influenced by the thoughts of Mahatma Gandhi. Many of them went ahead to take blessings of Mahatma before they could go to the Constituent Assembly. He was then, I think, in Gujarat only. So they went and they met him. And while they met him, they asked that what should we keep in mind before we go and draft the constitution. So he mentioned of a situation that when you sit there and draft the constitution, just think about the most underprivileged, most weak, most disabled person that you've met in your life, and try to think that whatever law, policy, provision you are making, it should come to some help for that particular person. It should empower that particular person. If you start from this perspective, I think you will make a good constitution. And I think there could be no bigger and better example of socialist policy than this. You think about the weakest, and I think you will get the most socialist of constitutions or socialist of provisions in the constitution, right? So these two having been said, the fourth part is rule of law. I think rule of law is by far very much known to all of you. Not starting from how A.V. Dicey defined it, the broad idea of rule of law is that governance in the state is to be carried out by the law or the prevalent law rather than the whims and fancies of persons, right? So rule of law basically means that whosoever remains in the state, whosoever, regardless of being in the institution, political institution, or outside it, will all be governed by law. And this will give us a sense of equality and predominance of legal spirit, as A.V. Dicey put it, right? So yeah, so rule of law here would mean that if in India we have a commoner and we have a president of India, we have a governor, we have prime minister, we have council of minister, whosoever they are all governed by a mechanism called law. There could be different extent of law applicable to each one of them. A president of India might be having some immunities which a common man would not have, but the president is also obliged to this law, and we are also obliged to law. This is the commonality that comes. So rule of law is one of the very, very fundamental features of the Indian Constitution. The whole discussion probably starts from there, that we would no longer want to be governed by the whims and fancies of anyone. We would be governed by a system in place, established by law, right? Now, again, law is a very wide term in itself. It could have different sources. So inclusive of all that, you see that, okay? Now, the next is judicial review and independence of judiciary.
Udit,
Now, I have dedicated a complete,
Udit,
sir, sir,
Udit, just I want to add one thing in the rule of law. So in the rule of law, there's one
sir,
other
please.
term which is very similar to rule of law, is rule by law. Is there any difference between rule of law and rule by law? So whether in India we have rule of law, in India we have rule by law. Is there any difference between rule of law and rule by law? So technically, we say that whenever a country is under the monarchy, whenever a country is under the dictatorship, generally we say that that country is governed by rule by law. So what will happen in rule by law is that there will be some person or some authority which is always above the law. So he can change the law whenever he wants. He can amend the constitution, anything whenever he wants. There is no restriction on that particular authority or that particular individual. So for example, if we take the case right now in North Korea, so in North Korea, there is one person who is above everything. Is it clear? So of course, king is the law and law is the king. So in India also, we can say that for a brief period of time during the national emergency in 75 to 77, some people say that there was a time when technically we were governed by the rule by law. But apart from that brief period, India was always under the rule of law. So there's a huge difference between rule of law and rule by law. If your country is having the constitutionalism, it will always be having rule of law. If your country is having rule by law, then your country will not be having the constitutionalism. So technically, rule of law and rule by law cannot go together. So they are exactly opposite to each other. Either you will have rule of law or you will be having the rule by law. Okay, we'll continue.
Thank you, sir. I think this has certainly enhanced the understanding. This was needed. So the last point that I talked to you about is judicial review and independence of judiciary. So I have taken a complete different slide for this one because out of every feature, this is one stark feature, one very important feature that all of us as students of law needs to pay attention. Judiciary conceptualized at an equal pedestal with other organs of the state. There is legislature, which is having its own domain of operation. There is executive, which is having its own domain of operation. There is judiciary, which has its own domain of operation. But you can find, if you look sincerely, that judiciary has an upper edge over the other two organs of the state, although they have their own scope of operation. But if you really examine properly, judiciary is not at the equal pedestal. It has a little above pedestal than compared to other two organs of the state because it is conceptualized as a guardian of the constitution. How laws are enacted, how laws are being implemented must be in accordance with the provisions and spirit of the constitution. To ensure this, judiciary has been empowered with a power that is called judicial review. Article 32, Article 226, the two very important jurisdictions of the court, which have almost become indispensable, indefensible, and those have acquired the um, uh, aspects of jus cogens in the Indian constitution, or the basic structure, as you could say, have a very important role to play. Now, Article 32 being identified, right to constitutional remedies itself as a fundamental right. So, right to constitutional remedy itself being a fundamental right shows us the level of importance that was given to judiciary with respect to reviewing the laws and the executive actions that impacted the rights of people. So, to safeguard the constitution, to safeguard the rights of the people, a specific emphasis has been made for right to constitutional remedies, which itself has been made a fundamental right. Right? So, that is one aspect. Uh, and second is, in a federal setup like we have a division of power between different at the union level and the provincial level or the state level, as you can say it. So there is a list which determines on which particular head of governance which institution can make law. So in this federal setup, there is a need of independent arbiter who would decide that if there is a dispute between two states, if there's a dispute between union and the state, if there is a dispute between state and the union, then who is going to decide this? So in a federal setup, judiciary acquires a specific important role, which Indian constitution also has, and therefore you must have looked into Article 131 of the constitution, which is the original jurisdiction under which the disputes between center and union, union and state, state and state, and union and state could be taken up. So, right, in a federal setup, judiciary acquires a very important position of its own as an arbiter of disputes between the various levels of government. Now, we have had sweet and sour both experiences with the judiciary, Indian judiciary. We've had seen judiciary being performing and holding the mantle of guardian of the constitution properly, and we've seen judiciary also sometimes disappointing the people of the country with this. Now, I'll just cite two examples of this sweetness and sourness, but regardless of that, independence of judiciary remains a very integral feature of Indian constitution and a very important feature in the governance also, because the more independence of judiciary is lost, the more constitutionalism becomes vulnerable, and it will be getting diluted day by day if the spirit of independence of judiciary is getting diluted. Now, the two judgments that I've here mentioned is one is Keshwanand Bharti and ADM Jabalpur. ADM Jabalpur versus Shivakant Shukla, a very famous case, very criticized case, referred as the dark day of Indian judiciary, where you know the judiciary bowed down before the pressures of the executive, and there was only one judge, Justice H.R. Khanna, who could challenge the constitutionality of the Act, Maintenance of Internal Security Act at that point in time. So, Ashutosh sir, you want to speak something?
I want to just say that we have Professor Yogesh Pratap Singh. He is a National Law University Odisha registrar. So he's taking the whole topic on independence of judiciary. So I think because we have to
Okay.
take the question also. So I think we have given the base, and rest of the things, there's a separate lecture on this independence of judiciary. Otherwise, we will not be having much of a time for any
Sir,
questions.
just give me 5 minutes. I'll be summing up.
Okay.
Yes, sir. Yes, sir. I'll just sum up. In fact, I'll be responding to one question. So, Kashvan Bharti is one aspect where the judiciary is stepped in to limit the powers of the amending the constitution by an implied limitation that was nowhere found in the constitution. ADM Jabalpur is where there was instance judiciary could have used but could not. Now, Menka Gandhi versus A.K. Gopalan, I would want to hear respond to the question put by Neelam in the chat box. She mentioned that, sir, what is the difference between procedure established by law and due process of law? I think it is the same difference that is there between Menka Gandhi judgment and A.K. Gopalan judgment. If you read the A.K. Gopalan judgment, it is having a true positivist approach, that judiciary was too firm that if legislature has laid down a procedure established by law, then we will not be able to question the very procedure. We will not go further. We will just see that the procedure established by law is fulfilled while making legislation. If that is done, even if the legislature decides that a person is to be burnt to death as an execution punishment, we cannot interfere. That was one stand, which is procedure established by law. And due process of law is where Menka Gandhi pitches in and redefines whole Article 21 to test every law on the aspect of justness, fairness, and reasonableness. Right? So this is the difference broadly, which is a whole new dimension of adding natural law dimension to that positivist approach. Right? Now I'll quickly, the last slide that was there, I'll quickly sum up. I talked about the Indian constitution being revolutionary by undoing historical injustice to the vulnerable classes, untouchability, Article 23, Begar, abolition of forced labor, Article 24, abolition of child labor. These were all very revolutionary articles. Directive principles of state policy. To some students, I'm teaching labor law, and we have read the constitution from a labor's perspective, part 3 and part 4. And if anybody is there in the audience, you may appreciate that how revolutionary this constitution is, we'll realize. Now, protective, you know that there are specific provisions for vulnerable sections, whether it is on caste basis, whether it is women and children. So there, it is having a protective approach also. Article 13 subclause 3 clearly says that the meaning of law will include orders, bylaws, rules, regulations, which are subordinate legislation. So our constitution makers were clear that we will need a pragmatic setup of governance, and we welcome delegated legislation also in that way. We have already talked about India is a federal setup, but with a very strong union. As Ashutosh sir said, it is biased towards center. And even if we don't use the word biased towards center, we have to agree that it is too much concentrated. There's too much concentration of power with the center. If we compare the extent of power the center has in India compared to US, there's substantial amount of difference in that. Emergency powers, and the institution of governor, and there are certain other examples also. Having just one citizenship, that are all facets of a strong center. Separation of power with practical exception. We have in spirit tried to put separation of power by defining the functions of each institution. However, there are practical exceptions and overlaps, not that if parliament is empowered to make law, only parliament is making law. Administrative authorities are also doing quasi legislative exercise, and in fact quasi judicial also. So we have done practical exceptions to it. Even the Supreme Court has clearly said in a judgment of 1951 Delhi Laws case that separation of power is not a feature of Indian Constitution. But in my humble opinion, I believe that separation of power, as rigid as Montesquieu thought, or as rigid as in any other constitution of the world, we might not have, but we have the spirit of separation of powers in the Constitution. And the last part is it's a learned, modern, written Constitution. These terms might mean a lot of things if we spend some time with that, but I think we are sufficiently clear. By modern document, we are aspiring to be a welfare oriented, which is a modern approach of constitutional growth, and we finally envisage constitution as a living document. So I'll sum up with this, that since constitution is a living document, we also have to be alive and awake towards its understanding. With this note, I would like to thank you all for giving me an opportunity to interact with you. I would like to thank Ashutosh sir also. Now we can quickly move to Q&A, and there are few fundamental duties that are very dear to me. I would just this is already reflected in the slide, so I would just request you all to pay attention to these, and this will help you in contributing towards the state, the government, and the nation. Thank you so very much.
Okay, Udit, thank you for this lecture. Now we come to this question. So you can post your question also. So someone is asking whether the number of amendment will show how good is the constitution or not. So for example, I told that in USA there were 30 amendments, and in India we have more than 100 amendments. But you have to keep in mind, we cannot compare us to USA, because in USA they have their own separate constitution. So every state have their separate constitution, and only few subject matters are dealt in the constitution of USA. So they don't have to amend the constitution of USA. Most of the states have the power to amend their own constitution. So they don't have the need to amend the constitution of USA only. But again, there's a debate that whether we should amend the constitution in a very, very strict manner. For example, in some countries, if you want to amend the constitution, you have to go for a referendum. For example, in Australia, if you want to amend the certain parts of the constitution, you can only do it by referendum, which means you will go and ask the people whether we want to amend this part or not. For example, right now in Switzerland, so Switzerland is a one country which is never part of any world war, and it was also not part of a UN for a very, very long period of time. Now they are wanting to buy some fighter planes. So they need to ask the people of their country whether we need this plane or not. So they have to take permission. So there is referendum going on there. So they have to ask. But it is possible to go for a referendum in a small country like Switzerland or Australia, because the population of Australia is equivalent to the people who commute in India daily in trains. In normal times, more than 2/3 of people in India commute in the train. So you cannot compare with India and Australia. So in a way, India has some good mechanism of amending the constitution. So certain integral part of the Indian constitution will only be amended with the consent of the respective state assembly. But otherwise, I think, especially keeping in mind our diversity in terms of everything, I think we need certain little bit flexibility in amending the constitution. Otherwise, if the constitution will be rigid, then we have seen what happened in Sri Lanka, we have seen what happened in Pakistan, we have seen what happened in Nepal. So this is why in India we have adopted a little bit of flexible approach, that certain parts is easy to amend, certain parts little bit difficult, and most integral part is very difficult to amend, and especially after the Keshwan Bharti, certain parts cannot be amended. So right now we have 4 parts in the Indian Constitution. One part absolutely cannot be amended. Second part, it is amended with the state assembly consent. Third part, 2/3 present and voting. First part, simple majority.
Okay. So Ashutosh sir, I would just add to that part. Very correctly said that if we have more than 100 amendments, but if we include the amendments that are done by judiciary and changes that have come through judiciary, then I think the list would be far more. But we'll have to see the effect of all that. I think comparing it with the USA, we have to have some common factors and distinguishing factors, and having an approach which is both flexible and rigid as per the requirements. I think that is the best approach, and I think that has helped our system to keep a robust system of mechanism, as well as to make it grow like a living document, like 21A being added as right to education being a fundamental right. That is a welcome thing. So, and
okay.
So yeah,
Okay,
I think the approach is best.
Okay, Abhishek, you're asking, I think the concept of basic structure came to safeguard the superiority of judiciary over parliament. I completely disagree with this statement, because there's nothing called as whether judiciary is superior or parliament is superior. Both are creature of the constitution. So basically, basic structure doctrine is basically covering the supremacy of the constitution over everyone. So it is saying that constitution is supreme. Why? Because at the end of the day,
Yes.
Parliament is a creature of the constitution. So parliament is not creating the constitution. Constitution is creating the parliament as well as the judiciary. So parliament cannot do something which will destroy the constitution. Same way, judiciary cannot do something which will completely undermine the parliament, because at the end of the day, do remember, parliament is accountable body. Parliament is elected body. So people have faith in the parliament because people have voted for them. So for example, yesterday in the lecture, that when you can challenge a law on the basis of the arbitrariness, in Article 14, reasonable classification and arbitrariness. But the problem with the arbitrariness test is that because it is very, very difficult to find out. And now what will happen, every law which is passed by the parliament, it will keep on going to the Supreme Court because you find it is arbitrary. So if we go with this arbitrariness test, then Supreme Court will completely come in the role of the legislature. And that is also not a good sign. Because at the end of the day, do remember,
Yes,
politicians have gone to the jail in India. Politicians have been punished. But we have to remember that till now we haven't impeached any judge. It doesn't mean that we don't have a corrupt judge. Just for safeguarding the independence of judiciary, it's a very, very difficult to remove them. So you don't have to give altogether higher status to the judiciary. Of course, they are very, very integral part of our governance, but so as the parliament. At least in parliament, we can remove them after 5 years. So basically, the doctrine of basic structure is
right.
proving the supremacy of the constitution over everyone else.
Exactly. Yes, I too disagree with your statement, Abhishek, on the same grounds. Just adding this thing, somebody has asked that does basic structure doctrine apply to constitutional amendment or ordinary laws only? You'll have to see the evolution of the concept of basic structure doctrine through Keshwan and Bharti case. You have to read it along with Article 368, Article 13, and the implications. So yes, it is only limited to constitutional amendment and not to ordinary laws, because for checking ordinary laws there is already an existing mechanism in the constitution in the form of part 3, in the form of legislative powers, and there is other checks and balance. But as far as basic structure doctrine is concerned, this is specifically for the constitutional amendments, uh, and therefore, as sir said, parliament is the creator of the constitution. Similarly, you should see that a government is elected by by having the elections which are conducted as per the constitution, and now this government wants to overall change the whole constitution, do away with the very essential tenets of the constitution to uphold the supremacy. This doctrine was created by the judiciary in a way. So therefore, we should. It is improper to say that it is to uphold the supremacy of judiciary. Rather, this was the essential function that judiciary should have done to safeguard the spirit of constitution as a custodian. Right?
Okay, Udit, there's
Can you
one
please
thing.
suggest a book for knowing the
Udit,
detailed history? Sorry, you can. Yes, sir.
एक minute. Sahil is asking what will be the consequences if the state is not following the guidelines which are laid down by the center. So Sahil, there is Article 365 in the Constitution. If you read, you will find effect of failure to comply with or to give effect to directions given by the union. So you can read Article 365, you can read Article 256, you can read Article 355. So if all these articles will tell you that if the state is not following the guidelines which is given by the center, then there's a great chance it is a perfect ground of imposing the precedent rule. It is a ground of imposing the precedent rule because it is clearly mentioned in Article 365. So if you read that, you will get your answer.
Okay. Prachi, you happen to ask a difference between federal constitution and a federal government. So, Prachi, federal government basically is the center, like we call it central government in India. The union government is called federal government, right? But so federal government is a creature of the federal constitution. You can say the union part or the center part is referred to as federal government, nothing else. There's a complete difference. Constitution is the one which creates the government, and government is the body which functions to fulfill the aspirations of the constitution, right? So sir, can you suggest a book for legal history? I would
Okay,
suggest that there is
I
a
will
book
suggest
written
you
by
to
our own professor.
I will suggest you to
Yes, sir.
read the
Sir, you may
book
suggest.
The Indian Constitution, Cornerstone of a Nation by Gladwin Austin. That is a perfect book which will give you a
Yes.
how the Constituent Assembly have worked. So this is a book by Glanvin Austin, Indian Constitution, Cornerstone of a Nation. Recently, there's a book, 16 Stormy Days, which is talking about the First Amendment to the Indian Constitution. That why the government was compelled to bring the First Amendment to the Indian Constitution. But at the end of the day, Glanvin Austin book is very, very good. I am writing the name, okay?
Yeah, sir, I've written. Abhishek, I would
Okay.
I would request you start with Granville Austin only. 16 Stormy Days you should read only after you've read the basic test, because Granville
Yes.
Austin is more of a commentary, right? And 16
Yes.
Stormy Days is like a proper book, right? So Divya Jain happens to ask, to what extent independence of judiciary is questionable? I missed out on the question. Is questionable its recent decision on instances such as Vikas Dubey encounter and many other recent instances. Okay. Look, independence of judiciary. Look, there has to be a balance between judicial. There has to be some sense of accountability with the judiciary also, right? So we have attempted to bring some kind of accountability through different legislative tools also, but that has not been possible. That has not been possible over the years. Even the recent NJAC constitution of NJAC for dealing with the opaqueness in the judicial appointment, so that also could not fructify. So there is, I mean, we have to weigh between the evils and and the benefits of having an independent judiciary, even at the cost of opaqueness. If we are able to maintain constitutionalism through judiciary, then I think it's a fair bargain. And this is the whole reason why we've been still carrying on with this. Okay, now, but there are questions with regard to independence of judiciary, and we as a legal system are really struggling to find out how do we make the judiciary accountable, in what sense. So
Okay, to supplement
I
your
guess we are still.
Udit, to supplement your answer, that
Sir, you
if
speak.
we
Yes, sir.
want,
Please go ahead.
if you, because there's a very delicate balance between independence of judiciary and accountability of the judiciary, because this is the reason why what happened during
Exactly.
the emergency, that when the government wanted to control the judiciary, they appointed junior judge as a CJI after the two judgments, be it the Keshavan Bharti and be it the judgment of the ADM Jabalpur. And thereafter, the Supreme Court realized, because Supreme Court realized that they have to revive its reputation, because what happened in the ADM Jabalpur case, that was regarded as the worst decision given by the Supreme Court of India till now. So after that, you will find the Supreme Court gave the judgment of the Menka Gandhi, and from there, the whole process of the judicial activism, the PIL movement started in India. But at the same time, no doubt, there's need to be reform in the judiciary also, especially regarding their, of course, regarding the Prashant Bhushan case. Of course, in my opinion, the Supreme Court should not step in, but at the same time, Supreme Court cannot completely ignore it, because of the simple reason that he made certain tweets. So in my opinion, the tweet regarding his personal life and the life of other thing, that is fine. But when he said that you have locked down the judiciary for so many days, you have locked down the judiciary for almost 140 days and you are not doing anything on record, would have decided more than 500 cases since March till July. So at the end of the day, you cannot completely ignore those statements also. If you are working, then why you are saying that you are not working? So there is ample evidence that Supreme Court have worked during the lockdown. Kindly see the number of cases they have decided. And you have to keep in mind the various restrictions and all those things. So what I am trying to tell you is that don't go with anyone's opinion, because constitution, the beauty of the constitution is that it can be interpreted in many ways. So if you are going with the opinion of the Faizan Mustafa, on one hand, you should also read the opinion of the Harish Salve, who is giving altogether different opinion. So as a law student, you should be knowing different opinion rather than following one opinion. Of course, you are free to form your own opinion, but at the end of the day, it's always better to read different opinion on the subject matter. So everyone have their own political biasness, everyone have their own biasness, But at the end of the day, as a law student, the beauty of the law is that what is a dissent right now may be the majority judgment tomorrow. You should be knowing the different version of the same thing. So if you are reading Faizan Mustafa, if you are reading some other people who are criticizing it, then you should read something from the Harish Shalve, something from other side also, just to have a different perspective. Is it clear, Gautam?
Yes, sir.
So Gautam, is there any question which is left?
No, sir, there are no question.
Okay, so anyone, any question which you have,
We have last
any
10 minutes, or
suggestion?
anyone want to ask something, they can ask. Is host also allowed to ask some question?
Yes, yes. Why not?
Sir, largely on the Abhishek Kumar Srivastava. So largely on Abhishek point of view that whether the basic structure doctrine is has been brought in by the judiciary for supremacy. I may not see that statement in that direction, but if we take the judicial approach into consideration from Sajjan Singh to A.K. Gopalan to Menka Gandhi to Keshavananda Bharati to Shaira Banu or to the recent privacy judgment or to the internet curtailment of the Justice Ramanna judgment of the Kashmir, I certainly
Okay.
see that basic structure doctrine is a parallel constitution in itself, which is
Okay.
undefined without any element, like there is no surety which element is there
Okay.
in the basic structure, which element will be added. You don't know there will be some case in the future and a new element will be there in the basic structure, will be incorporated in the basic structure. So a clearly undefined doctrine, and I think it possesses a parallel constitution in itself.
Okay, but what I'm trying to tell you is that, see, in India, unlike USA, in USA, the judicial review power came through a Supreme Court judgment of Marbury versus Madison. So in USA, they don't have this judicial review power till the time the Supreme Court is giving the famous judgment in USA in the case of Marbury versus Madison. Unlike USA, in India, we from the very beginning have Article 13, Clause 1, 13, Clause 2, which say that any law which is inconsistent with the fundamental rights shall be void to the extent. Same way, we have Article 32, 2 to 6, and Article 136 of the Indian Constitution. So in that particular scenario, if we see that Indian Supreme Court is much more powerful, because do remember Indian Supreme Court is having Article 142, and that Article 142 you will not find anywhere in the world, that the Supreme Court can pass any order, can pass any direction for doing complete justice in any of the case. If you read Article 141 read with Article 142 of the Indian Constitution, you will find, in my opinion, the Supreme Court of India is the most powerful Supreme Court all over the world, because even in USA they don't have such power. So Article 42 is very, very unique. Of course, you can question that basic structure doctrine is a parallel constitution, but you have to remember that at the end of the day, when the Bhimrao Ambedkar said in the Constituent Assembly also that we have this judiciary as a guardian of the constitution, we are giving them the judicial power. So somehow the intent of the Constituent Assembly of India is that whenever the legislature will go wrong, whenever the executive will go wrong, because they have their own political compulsion, they have their own political ideology, they have their own, say, manifesto which they want to implement and all those things, there should be someone who will tell them that, listen, you are going wrong way. So if they don't find the answer within the
Exactly.
constitution, they don't find the answer within the constitution, because constitution is not saying anything about what can be amended, what cannot be amended. It is simply saying that parliament can amend the constitution. Is it clear? So generally what happens in such scenario, in my opinion, that will be the role of the Supreme Court to step in, because they have a vast power under Article 142 of the Indian Constitution, which they have used number of times, be it the Ayodhya dispute, be it any dispute. Otherwise, you will not see such thing coming in any other jurisdiction anywhere in the world. So that's my take on this particular issue.
So Gautam, I'll also respond to your question in a minute. I fundamentally agree with what Ashutosh sir said, because when basic structure doctrine came, it came with a very, very effective purpose, and had it not come, we would have had complete subjugation of the whole constitution principle at the hands of executive, at the hands of legislature, which would have disturbed the whole balance, fine balance that was envisaged to be created under the constitution. However, when Ashutosh sir referred to Article 142 and said that if we read it with Article 141, it makes Indian Supreme Court almost the most powerful Supreme Court of the world. But that would only be possible if we impute the meaning it has been imputed under Article 142. There is a little disagreement on the ambit of Article 142 here. There is a reading of Article 142 which says that Supreme Court has again widened too much its interpretation under Article 142. The idea of complete justice that was envisaged under Article 142 was not totally unguided and totally to make it court of justice. The idea was to for enforcement of decrees and order. It was also limited by certain aspects. But anyway, whatever has been under basic structure doctrine, also it started with a very noble purpose of defending the constitutional principles. Now, possibly by adding a lot more things, it might not be very proper. It might create a scope for again going in the wrong direction. Now this time the judiciary will deviate. And second, like Article 142, we have the idea of complete justice, but Supreme Court again widened Article 42 to 142 to such an extent that now Supreme Court can possibly do anything and everything under Article 142 without any limitation, which is I don't know which is again proper or not. So
Okay.
yes, Gautam, this is my submission.
Okay. There's one question from Misha. Okay, regarding this cow slaughter and all those things. So we will read in the coming classes the case of Mohammad Hanif Qureshi, and many think whether it is based on religion or it is based on economic factors. So you will be able to find the answer in coming days, because I don't want to tell you the exact answer right now, what I think, because it should be told by the people who is going to touch this topic. So I think, and of course I am here to give my answer anyways. So, but you will find the answer in coming lecture. And regarding this whole concept of control, so in my opinion, it is always better to have an uncontrolled judiciary than have a controlled judiciary. Same like it's always better to have an uncontrolled media than to have a controlled media, because when you start controlling the media, you never know what will happen with the media. Because it's always better to,
Yes,
if I have a two option, whether to control the media or to leave the media as it is. All over the world, the general perception is that it's always better to have an uncontrolled media as compared to the controlled media, because that is more dangerous. So this is all for today, because I think at 6 we will be
certainly
logging
an
out.
uncontrolled judiciary.
Yes. So this is all about today. So thank you all for your patient listening, and do join us tomorrow. So tomorrow Dr. Parth will take a lecture on the certain basic terms which is used in the Constitution, and day after that, Mr. Vishal Sharma will be taking the lecture on the citizenship and the whole concept of the union territory and the state. And then we will start with the next week on Friday. We will be having lecture on Article 12 by Vijay sir. So thank you all.
Thank you, everyone. Thank you, sir.
Okay, thanks a lot, Udit. Thanks, Gautam.